So which of the following sections of IPC deals with theft? Of course, we'll discuss IPC. We did not discuss it, but I think at the end of Constitution, we will discuss in criminal law in one class. Which of the following sections of IPC deals with theft? Anybody in the class? So it is answer. The answer is 378. So 378 talks about theft. And see, generally, if the first section is related to a definition, then mostly the second and third one will be also something related to that. Okay, like for example, 379 is punishment for theft. In 379, punishment for theft is prescribed, and in 380, there is a very different thing, that is theft in a dwelling house. So what is a dwelling house? So dwelling house is a house in which somebody is living, which means that somebody is already there in the house. But when generally theft happens when nobody is there in the house, right? So that is a general definition of theft. And here it is a very specific thing. When if somebody is there in a house and if you're going and committing theft, then for that section 380 is there. And 377 is related to certain unnatural offenses. So Supreme Court 2 or 3 years back, it's been 4 years, right? So 4 years back, Supreme Court gave a judgment in which it stated that, section 377, to the extent of people who are homosexuals or people who are from the LGBT community, it is unconstitutional for them, to that community. And for other unnatural offenses, they are offenses. You cannot have intercourse with animals and various other creatures. That is completely unnatural. But to the extent of the people from LGBTQ, it is considered as unconstitutional. Okay, we'll discuss about that in various cases. We'll be discussing Nas Foundation and various other cases in important case laws. Next, under which article can the president declare a national emergency?
352.
Article 352 is national emergency. 356 is president's rule, or in our colloquial terms, it is state emergency. And 360 is financial emergency. And 350 is not related to emergency. I think it is related to usage of language for any grievance redressal. Like if you have any grievance, if you have any problem in the state, so in which language you have to submit the complaint in various states, and in which language they should give the reply. All of these very trivial things are there. 350 is not a very important article for your exam, but 352, 360, 356, and 365 are very important articles. And of course, in tomorrow's class, we will be talking about emergency, so don't worry about it. Next, principal fact-based question. This is known as principal fact-based question. Here, you don't require in most of the cases, you don't require the prior knowledge of law. You just have to read the question. Whoever takes away any movable thing from the land of any person, without that person's consent, he is said to have committed theft. So which means that you have to take a movable thing, not an immovable one, and that too without the person's consent on his land. So then you'll be committing theft. During his visit to the house of C, A asked B, the son of C, to accompany A to the forest. Okay, neither A nor B informed C in this regard, which means they did not tell his father that I'm taking your son to the forest, and B accompanied A to the forest. Is there any theft over here?
No, sir.
So can you consider B as a movable object? The answer is no, right? So A has not committed any theft. Okay, next. The power of Supreme Court of India to decide disputes between the center and the state falls under its very important question. I've discussed it in the class. Why is this blinking? Yeah. The power of Supreme Court. So the answer is original jurisdiction. So original jurisdiction of the Supreme Court under Article 131. If there is any dispute between the center and state, and between two states on one side and center on one side, so all of these things, they fall under the original jurisdiction of Supreme Court. Next one is appellate jurisdiction, which means appeals can lie from the high courts to the Supreme Court under Article 132, 133, and 134. Advisory jurisdiction of the Supreme Court, very important and very favorite article of yours, that is Article 140. Then writ jurisdiction of the Supreme Court is under Article 32. Okay, so these are important articles which you have to remember. Next, another principle fact-based question. A principle is said to have, this is principle. A person is said to have committed assault. I discussed about assault when we were talking about law of torts. When an apprehension here, see, whenever you are answering principle fact-based questions, you should not apply your prior knowledge of law. Okay, you have to stick to what is given in the passage. Okay, so a person is said to have committed assault when an apprehension is caused in the mind of a person that he is about to use physical force against his body. Okay, which means that fear should be created in the mind of the other person that some damage is going to happen to his body. Next, A abuses B while he was sitting in a moving train by aggressively shaking his fist. So this is his fist. So he's aggressively shaking this. My pen is getting damaged on here. So he's aggressively shaking his fist. Why? When B was standing on the railway platform. B is standing somewhere on the railway platform. This fellow is there in the moving train and he's shaking his fist. Now, is there any assault over here? Is there any assault?
No.
No, because it says that if assault has to be created, there has to be an apprehension in the mind of the other person. Okay, B should get that fear, right? Okay, this fellow is going to punch me. But is it given anywhere in the facts? No. So A has not committed assault against B. Okay, so C is the right answer. C is the right answer. Next. Very important, defamation. I have again discussed when we were talking about torts. Defamation is a publication of a statement which tends to lower the reputation of the person in the estimation of other members of the society generally. A writes a highly offensive and derogatory letter about B and sends it directly to B in a sealed cover. Is there defamation?
No.
No.
No. Why there is no defamation? Because
Nobody is going to read.
Nobody is going to read. There is no third party. So when there is no third party, his reputation is not going to be lowered. Okay, if you and I are talking something very bad, very offensive, it is only between you and me, not in the society. But when I abuse you or when I say something defamatory in front of the public at large, then it becomes defamatory. So A is not liable for defamation because there is no publication to another person. Okay, next. Another principle fact-based question. An agreement without free consent, this is slight question. So an agreement without free consent can be enforced only at the option of the party whose consent was not free. What is this agreement? If you have attended the law of contracts class, you will be able to know it. What is this known as? It is known as voidable contract, voidable agreement, which means that it is void only if the party whose consent was not free, if he wants to make it void, he can make it void. Okay. Next, A obtains the consent of B to enter into an agreement by putting a gun on the head of B's girlfriend, which means, do you think the consent of B is free? So did B give his free consent? So if there has to be a free consent, then we discuss certain essentials. There should not be undue influence. Okay, there should not be coercion. There should not be force. There should not be misrepresentation. We have discussed all of these when we were talking about law of contracts. Looks like I don't know how many of you have answered. So when the consent is not free, can you enforce the agreement? No, you cannot enforce the agreement. But generally what I feel is that like both can be correct. B can enforce the agreement or B cannot enforce the agreement because it says that it can be enforced only at the option of the party whose consent was not free, which means that as B's consent is not free, B can generally enforce the agreement or he cannot enforce the agreement, which means he can make it void. But if you look at the general principle is that an agreement without free consent cannot be enforced. Okay, so that is why we took this answer, that is B cannot enforce the agreement. Next, 53. Rajya Sabha has equal powers with Lok Sabha in
Amending the constitution.
In amending the constitution, because in creation of all India services, Rajya Sabha has more power when you compare to Lok Sabha. Removal of power exclusively to Lok Sabha because the Council of Ministers headed by Prime Minister are collectively responsible to Lok Sabha. No confidence motion cannot be moved in Rajya Sabha. And in making cut motions. So cut motion is something which is moved at the time of budget to cut the grants which are given. Okay, and the cut, as you know, Lok Sabha is the complete has a complete power with respect to money bills. So cut motions are also, Lok Sabha has more power when you compare to Rajya Sabha. So only in amending the constitution, Rajya Sabha has equal powers with Lok Sabha. I mean, with respect to this question, but in ordinary law, both Lok Sabha and Rajya Sabha have equal powers. Next, 54. A person who is usually of unsound mind but occasionally normal may make a contract when he is not of unsound mind. Okay, so A generally remains in the state of unsound mind and rarely becomes capable of understanding things, which means very rarely, chala takwa samayallo, he will be able to understand the things. In most of the cases, he won't be able to do that. Now, look at the options. A can make a contract when normal. A can make a contract only for his own benefit. A can never make a contract. A can make a contract at any time whenever he pleases. What is the answer?
He can make a contract when he's normal.
A can make a contract when he is normal, which means when he is of sound mind, he can definitely make a contract. Next, which of the following?
What is meant by pleases?
Sorry.
Make a contract at any time whenever he pleases.
Yeah, it means that whenever he wishes. So whenever he feels that he wants to make a contract, that is the meaning of it. Okay, so that cannot happen. So he can enforce only when he is of sound mind. Did you attend the class on law of contracts? There I made a thing like, the person competency to contract. Person should be of sound mind. He should be a major, not a minor. So we've discussed all of them when I was talking about law of contracts. If you did not watch it, please go through the recording and come back again. Next, which of the following is not a codified law?
Tort law.
Tort law is not a codified law. It is based on judicial precedents and there is no codified law. For civil law, for criminal law, and for contract law, we have various acts. Next, which of the following is not included within the meaning of intellectual property?
Trademark.
Property of an intellectual.
Property of an intellectual. Patents, copyrights, trademarks, geographical indications, all of these are a part of IPR or intellectual property rights. We did not discuss this chapter yet, but we'll discuss it, don't worry. So what are patents? So patents are the intellectual property rights which are given for inventions. For example, the laptop which I'm using has certain invention. Okay, they've made in this has a patent, or maybe the fan or the whatever, maybe this pen tablet, it has certain invention. So they are given to patents. And second one is copyrights. So copyright is given for the content that is created. It might be for any piece of information. Like for example, there is a book over here. So if for this book, the copyrights are vested with, this company, whoever it is, whoever is the company, they have the complete copyright over this one. If you are creating a music, you have the copyright over it. If you're creating a dance, you have a copyright over it. Trademark is given. Trademark is for businesses or whenever you are trading something. For example, this particular pen tablet is manufactured by XP Pen. So it is a tablet which is used. If I'm writing here, it will be visible on my screen. If you can look over here, their brand name is prescribed over here, right? And I think it is there in the backside as well. So this is a trademark. Okay. If you look at my laptop, it is a Lenovo laptop. So the word Lenovo and the logo, whatever is there, it is a trademark. It is used while discussing. And of course, for all of these things, you will be able to find it. This is a pen. Every pen has a trademark. That is a trademark. Even the t-shirt which I'm wearing, I don't want to disclose the name of the brand, but however, this is also the trademark of the company. Okay. So that is what. And then we have geographical indications. So geographical indications are given for certain areas, certain products which are specific to a specific geographical region. For example, Hyderabad Halim. Hyderabad Halim has geographical indication, GI tag. Hyderabadi biryani does not have geographical indication. There is no GI tag for Hyderabad biryani. Last year, only those students who paid very close attention in all my practice sessions, they marked this question correct. They asked in the exam, which of the following product from Hyderabad has geographical indication? Whether it is Halim or biryani or some kheer, and they given some options. Only those who attended the class very clearly, who paid complete attention, they answered it correct. And those who were just, making these, just looking, on the top, so they did not answer it. So please pay very close attention in the class on each and everything that is discussed. Okay, next. So intellectual property is what is generally property is something which is physical, right? You have the land, so the house in which I'm staying is a property. But intellectual property is something which is created by the intellect. Okay, the patent, whatever is it, the copyright or trademark. So all of these are intellectual things. So that is why it is. Whereas property of an intellectual, what is the meaning of property of an intellectual? It means that property of somebody who is an intelligent fellow or intellectual fellow. So that fellow's property, it might be physical property, or it might be Bitcoin, okay, or it might be anything else. So we cannot say whether it is intellectual property or not. Next. Audi alteram partem means, what is the meaning of this? If you have attended my
Giving
class,
opportunity of hearing of others.
Giving opportunity of hearing of
so
the
giving
other
opportunity
side.
of other side. Audi alteram partem means that let the other side be here. Now, very recently, I filed a case against somebody. So when I filed a case against somebody, court asked the other party to come. Dear other party, come to the court and tell me your version. What do you think? Is it true? Did you do this? If yes or if no, what is the evidence? So you have to give the option for other party to hear. If other party you're calling him and if he is abstaining, then that's a different thing altogether. But you should give the opportunity for the party to hear. Nobody should be condemned unheard. Okay, next. Law never enforces an impossible promise. Facts. A made a promise to B to discover a treasure by magic. Will law enforce this contract or will not enforce this contract? What is the answer?
Will not enforce the promise.
Law will not enforce a contract because it is an impossible promise. Okay, because whether you can discover treasure by magic, it is not a certain thing, right? Like if I made an agreement saying that I want this house and the rent of this house is 20,000, and when you are giving the house, I'll be promising the landlord to give 20,000. It is a certain event. We can definitely give. But what is magic? Can you discover a treasure by magic? It is uncertain, right? So that is why it is not. Law will not enforce it. And public holidays are declared under. It is declared under the negotiable instruments. Next, offenses which can be compromised between the parties are known as
Compoundable offenses.
Non-compoundable offense.
Compoundable offenses. So in compoundable offenses, compromise can be made. That is why it says compoundable. It can be compounded. It can be compromised. Whereas in non-compoundable offenses are of serious nature, like rape or maybe murder, these kind of things. They are non-compoundable. In these cases, parties cannot strike a compromise. They cannot come to a compromise. And what is cognizable and non-cognizable offenses? I think we did not discuss criminal law, right? So we'll discuss when we are talking about criminal law again. So cognizable offenses are those offenses in which police can arrest a person even without a warrant, which means they are very serious nature. Whereas in non-cognizable offenses, police cannot arrest a person without a warrant. So there should be warrant from the court to arrest in non-cognizable offenses. Whereas in cognizable offenses, police can take direct cognizance without getting warrant from the court. Okay. So this brings me to the end of mock analysis, and let me stop the recording. And if you have any doubts, you can ask me now.